The call came at 11:40 at night. My neighbor, not the type to call late without a reason. He said something was wrong at the property. Sounds he didn't recognize. Movement. I thanked him, hung up, and called the police. I did not get in my car. I stayed exactly where I was. The officers arrived to find my tenant inside. The eviction scheduled for 7 hours from that moment, surrounded by damage that doesn't happen by accident. She was arrested that night. Everything she had spent months trying to do to me, she had just done to herself, in front of witnesses, in uniform. I found out the next morning when I drove over in daylight to see what was left. But to understand why that phone call was the end of the story and not the worst of it, you need to hear how it all started. I want to be clear about something from the beginning. I am not a professional landlord. One property, a flat I had owned for several years that made more practical sense to rent out than leave sitting empty. A reasonable decision made by someone who had done enough research to feel prepared and not quite enough experience to know what prepared actually meant in this context. I went into it carefully. That detail matters to what follows. I listed the property properly. Honest description. Fair price. When applications came in, I reviewed each one thoroughly. Employment, income, rental history, references from previous landlords and employers. I was trying to find someone who could afford the place and would treat it with basic care. That assessment, I would learn, is harder than it looks from the outside. References can be managed. First impressions can be managed. The version of yourself you present at a viewing is not necessarily the version that settles into a property 6 weeks later. I didn't fully understand that yet. Lisa applied in the 3rd week. Strong application. Professionally employed with a salary that comfortably cleared the income threshold. A positive reference from a previous landlord. Clean employer reference. She was polite in her messages, prompt in her replies. She asked sensible questions before the viewing, the kind that suggest someone genuinely thinking about whether a place fits their life. She arrived on time, presented herself well, and said she was a quiet tenant who worked long hours and valued a peaceful home. Everything she said was exactly what I was hoping to hear. I offered her the tenancy a few days after the viewing. She accepted the same day. We signed the lease in person. I walked her through every clause, payment terms, due dates, notice periods, her responsibility to maintain the property, and report issues promptly. She listened, asked a couple of genuine questions, and signed. I handed over the keys. I had used a solicitor to prepare the tenancy agreement rather than a generic online template. It had cost more. It was entirely worth it. The property was in good condition. The paperwork was solid. The tenant had checked out on every measure I had applied. I told myself I had set this up correctly. The first month confirmed it. Rent arrived 2 days early. No noise complaints. No unnecessary contact. Just a quietly occupied flat generating income and asking nothing of me. Second month, identical. I started to relax. The landlord horror stories I had heard began to feel like things that happened to people who had been careless, who hadn't done their homework. I had done my homework. I had the documentation. I had chosen carefully. I told myself I was going to be fine. Third month, rent didn't arrive on the due date. I waited 2 days, then reached out politely. Lisa replied the same day. A banking issue. Transfer hadn't processed correctly. She would sort it within the week. Money arrived 4 days later. I accepted the explanation. A single late payment after 2 months of punctuality is not a pattern. I noted it and moved on. Fourth month, late again. Different reason. An unexpected personal expense. Short-term cash flow problem. She would have it to me within 10 days. One late payment is an incident. 2 consecutive late payments with 2 different explanations is something else. The beginning of a shape I was starting to see. I replied professionally. Said I understood that difficult months happen, but that paying on time was a fundamental condition of the agreement we had both signed. Her response had a quality I hadn't encountered from her before. Clipped, slightly defensive, as if being reminded of a basic obligation was an imposition she was tolerating. I noted it. The money came through 9 days later. 5th month, I already knew before I checked. I sent the formal notice the tenancy agreement required. Correct wording. Correct delivery method. Documented with date and time. Lisa didn't reply for 5 days. When she did, the civility was largely gone. The message was defensive and aggressive, disproportionate to a standard late payment notice. She questioned whether the notice had been sent correctly, said she knew her rights, used the word harassment in a context that had nothing to do with harassment. I read the message twice. Then I called a lawyer, not from panic, from clarity. The situation had moved past the point where reasonable communication was going to fix anything. What came next required precision, documentation, and professional guidance. That phone call was the best decision I made in the entire process. The lawyer's name was Peter. He came recommended through a colleague who had dealt with a property dispute a few years earlier. Straightforward, my colleague had said. Doesn't overcomplicate things. Tells you exactly where you stand. That description turned out to be accurate. I laid everything out in our first call. The lease, the payment history, the notices I had sent, the messages from Lisa. Peter listened without interrupting. When I finished, he asked a few precise questions, the kind that told me he already understood the shape of what he was looking at and was filling in specific gaps rather than building a picture from scratch. Then he told me exactly where I stood. The good news was that my documentation was solid. Every notice sent correctly. Every communication recorded. The tenancy agreement watertight. I had, without fully knowing I was doing it, been building a paper trail from the beginning simply by being organized and professional. That paper trail was now my most valuable asset. Peter explained the formal eviction process clearly. The specific notices required. The correct sequence. The timelines that had to be followed precisely because any procedural error, any deviation from the required process, could give a tenant grounds to delay or challenge the proceedings. He said, the process is slow and it has to be followed exactly. But if you follow it exactly, it works. I told him to proceed. What followed over the next several weeks was the methodical machinery of formal legal process. Notices prepared and served correctly. Deadlines documented. Every step taken in the right order at the right time. Lisa's rent continued not arriving, or arriving late and incomplete. Partial payments that kept the situation technically alive while making no real progress toward what was owed. I recognized this pattern for what it was. Not genuine financial difficulty. Strategy. Keeping enough movement in the situation to complicate the legal process while providing nothing that actually resolved it. Peter had warned me this might happen. I wasn't surprised. I just documented everything and kept moving through the process. Then the party started. I found out through a neighbor, a man who lived in the adjacent property and who sent me a politely worded message asking whether I was aware of what was happening at my flat on weekend nights. He described late music, groups of people arriving at odd hours, a general level of noise and activity that had been disturbing his household for several weeks. He had not wanted to escalate it. He was telling me because he felt I should know. I appreciated that more than I could easily express. I sent Lisa a formal notice regarding the noise complaints and the breach of the lease terms around use of the property. Documented. Correct wording. Correct delivery method. She didn't respond to that one at all. The neighbor messaged again 2 weeks later. Things had not improved. If anything, they had gotten worse. There had been an incident the previous Saturday. He described it carefully, and what he described was not the ordinary noise of someone enjoying their home. It was something more deliberate, more careless. The behavior of someone who has decided that the property they are living in is not something they need to treat with any particular respect. I sent another notice. I forwarded the neighbor's account to Peter. I kept building the record. Then something shifted. Lisa filed a formal legal complaint against me. I found out through a letter from the relevant authority, clinical, official language informing me that a complaint had been lodged and that I was required to respond within a specified time frame. I stood in my hallway reading it for a moment. The complaint alleged harassment. It alleged that I had been contacting her excessively and in an intimidating manner. It alleged that the property had maintenance issues that constituted unsafe living conditions. It alleged that the formal notices I had sent were part of a campaign to pressure her out of the property illegally. Every single claim was fabricated. I knew it. Peter knew it when I called him. And, most importantly, the documentation I had been keeping since the beginning of this process knew it too. Every notice I'd sent was correctly worded and correctly timed. Every communication was professional and factual. The property had been in good condition at the start of the tenancy, documented with a full inventory and photographs taken on the day Lisa moved in. There was no harassment. There was no unsafe condition. There was a landlord who had followed every legal requirement precisely and a tenant who had apparently decided that the best defense was an offense. Peter told me not to panic. I told him I wasn't panicking. He said, "Good, because this is actually not uncommon. And if your documentation is as solid as you've described, this complaint is going to collapse under its own weight." I sent him everything. Every message, every notice, every photograph from the move-in inventory, every record of every step I had taken from the day the first payment was late. Then I waited for the process to do what processes do when the facts are clearly on one side. The legal process moved at its own pace. That is the thing nobody tells you when you are in the middle of something like this. You expect urgency because the situation feels urgent. But the machinery of landlord-tenant law does not operate on your timeline. It operates on its own, methodical, unhurried, indifferent to the fact that your property is being misused and your money is not arriving, and someone has filed a fabricated complaint against you that you now have to formally answer. You just have to stay inside the process and keep moving. Peter guided me through the response to Lisa's complaint carefully. We went through every allegation she had made and matched it against the documentation. The harassment claim, dismantled by the record of every communication I had sent, each one professionally worded, each one sent at appropriate intervals with appropriate content. The unsafe living conditions claim, dismantled by the move-in inventory and photographs showing the property in good condition on the day Lisa took possession of it. The claim that my notices were an illegal pressure campaign, dismantled by the fact that every notice had been sent in precise accordance with the terms of the tenancy agreement and the relevant legal requirements. The response Peter prepared was thorough and calm. No emotional language. No counter-accusations. Just the documented facts laid out in the correct order against each specific allegation. I read it through before he submitted it. It was the clearest possible illustration of what good record keeping actually looks like when it matters. Every decision I had made to document things properly, every notice filed carefully, every communication saved, every photograph taken at the start of the tenancy, had compounded into something that now made Lisa's complaint look exactly like what it was. A fabrication with nothing behind it. I attended the first hearing with Peter. I want to describe how that felt because I think it is relevant. Walking into a formal legal proceeding where someone has made specific allegations against you, even allegations you know to be false, carries a weight that is difficult to fully prepare for. There is something fundamentally uncomfortable about being in a room where your conduct is being formally examined regardless of how confident you are in that conduct. I kept my composure. I answered what I was asked to answer and said nothing beyond what was legally relevant. Peter had prepared me for this, had told me clearly that the hearing was not the place for frustration or editorializing or any expression of how I felt about the situation. It was the place for facts, for documentation, for the calm presentation of a record that spoke for itself. I'll let the record speak. Lisa was present at the hearing. I did not look at her beyond what was necessary. I was not there to perform composure for her benefit. I was there to do what the process required and then leave. The hearing was procedural rather than conclusive. The case would need another sitting before a determination was made. Peter had told me to expect this. I accepted it, and we prepared for the second hearing with the same thoroughness we had brought to the first. Meanwhile, the eviction process was continuing on its parallel track. The formal notices had been served. The timelines had been followed. The documentation was complete. Peter had been clear from the beginning that the eviction and Lisa's complaint were separate processes. The complaint did not pause or invalidate the eviction proceedings, provided those proceedings had been conducted correctly. They had been conducted correctly. The second hearing came about 3 weeks after the first. I sat in the same room with the same composure. Peter presented the documentation. Lisa's legal representative made the arguments available to them, which, given the thinness of the evidence behind the complaint, were not strong arguments. They were the arguments of someone working with very little and trying to make it appear like more than it was. The determination came at the end of that hearing. Lisa's complaint was dismissed entirely, not partially upheld and partially dismissed, not sent back for further consideration. Dismissed. The presiding officer found no evidence to support any of the allegations made. The documentation I had provided was noted specifically. The clear record of professional conduct and correct legal process on my part had made the complaint impossible to sustain. I sat still when the determination was read. Peter gathered his papers. We stepped out of the room. He shook my hand in the corridor and said, "That is exactly what happens when you keep your records properly." I thanked him. The eviction order was granted shortly after. Lisa was given the formal notice of the date by which she was required to vacate the property. Legal. Properly served. Documented. I drove home that afternoon and sat quietly for a while. Not with triumph. Not with relief exactly. Something quieter than either. The specific satisfaction of a process that had been followed, correctly producing the outcome it was supposed to produce. The system had worked, not quickly, not without cost and time and legal fees and the ongoing low-level stress of having something unresolved, but it had worked. All that remained now was for Lisa to leave. I assumed she would. I assumed that having lost the complaint and having the eviction order formally granted, the practical reality of the situation would assert itself and she would vacate the property on the date specified. I was about to learn that my assumptions about Lisa's behavior had been wrong before, and they were wrong again now. The days between the eviction order and the scheduled date passed quietly. Too quietly, in retrospect. I had heard nothing from Lisa since the determination. No contact, no acknowledgement of the eviction notice. No communication through her legal representative. Nothing. I told myself that was fine. She had no legal avenue left, and perhaps the silence was simply the silence of someone who had accepted the inevitable and was making their arrangements to leave. Peter had advised me not to contact her directly during this period. The legal process had run its course. The order was granted. The date was set. Any direct contact from me now served no purpose and could only complicate things unnecessarily. I stayed away from the property. I stayed away from Lisa. I let the order stand and the date approach and told myself that the worst of it was behind me. I kept busy with other things. The legal process had consumed more of my mental bandwidth over the preceding months than I had fully registered while I was inside it. The hearings, the documentation, the careful, measured responses to each development. All of it had required a level of ongoing attention that I was only now, in the relative quiet of the waiting period, beginning to feel the weight of. I was tired, not dramatically, just the quiet tiredness of someone who has been managing something stressful for an extended period and can finally see the end of it. I thought about what came next. The practical things. Getting the property back. Assessing its condition, making whatever repairs were needed, finding a new tenant, this time with a more thorough screening process and the benefit of everything this experience had taught me. I had already made a mental list of things I would do differently, not because I believed I had done anything wrong. The legal outcome had confirmed I hadn't, but because experience teaches things that research cannot. I knew more now about what to look for and what to look past. About the difference between a strong application and a reliable tenant. About the importance of the early warning signs I had noticed and responded to correctly, but perhaps not quite quickly enough. Next time I would move faster at the first sign of pattern. Next time the lawyer would be called earlier. I was turning these thoughts over on an ordinary evening at home when my phone rang. My neighbor, the man from the adjacent property who had messaged me about the noise complaints. He had my number from our earlier communications, and I was glad he did. His voice had a careful quality. He said he was sorry to call late. He said he wasn't sure whether to ring, but something felt wrong, and he thought I should know. I asked him what he meant. He described sounds coming from the property. Movement. The kind of activity that didn't sound like someone packing their belongings in an orderly way. Something that had been going on for the last hour, and that had a quality he couldn't fully articulate, but that had made him uncomfortable enough to pick up the phone. I thanked him. I told him he had done exactly the right thing by calling. I hung up, and I called the police. I want to be clear about this decision because I think it matters. My instinct in that moment, the immediate, unconsidered instinct, was to get in my car, to drive to the property, to go and see for myself what was happening. I didn't do that because Peter had been clear throughout this process about one thing above all others. My job was to follow the correct process at every stage and let the appropriate authorities handle what fell within their remit. Go to the property myself in that moment, regardless of what I found when I got there, created variables I couldn't control. A confrontation, a disputed account of what happened. The possibility of something that complicated the clean legal outcome I had just achieved. The police were the correct call, literally and procedurally. I made it. I gave him the address. I explained that I was the property owner, that I had an eviction order for the current occupant effective the following morning, and that my neighbor had reported suspicious activity on the premises. They said they would send someone. I sat in my house and waited. The call back came 40 minutes later. The officer was matter-of-fact in the way that police officers are matter-of-fact when they're delivering information about something that is serious but contained. He told me they had attended the property. He told me they had found the occupant inside. He told me what the occupant had been doing when they arrived. I listened without interrupting. When he finished, I asked the question I needed to ask. He confirmed she had been arrested. I thanked him. I asked about the property, whether it was secure, whether I could attend in the morning to assess the situation. He gave me the information I needed, told me what the next steps would look like from a police perspective, told me someone would be in touch about the criminal damage documentation. I wrote everything down. Then I sat back and looked at the ceiling for a moment, not with satisfaction, not with anger, with something closer to a tired, quiet recognition of the fact that Lisa had been given every opportunity to leave this situation with some dignity intact, and had chosen, at the last possible moment, to make it worse for herself in a way that was irreversible. The eviction order was already granted. The legal complaint had already been dismissed. She had lost everything there was to lose through the correct legal process, and she had responded by handing the authorities a criminal charge to go with it. I set my alarm for early the following morning. I was going to need to see the property in daylight. I arrived at the property at 7:30 in the morning. The street was quiet, ordinary, the kind of unremarkable Tuesday morning that makes what had happened the night before feel slightly surreal by contrast. I sat in the car for a moment before going in, not from reluctance, just taking a breath before seeing something I suspected was going to require a steady response. I let myself in with my key. I want to describe what I found without dramatizing it, because the temptation when something like this happens is to reach for language that matches the feeling of violation, and the feeling was real. Walking into a property you own and finding deliberate damage is its own specific experience. It is not the same as accidental damage or the wear and tear of normal occupation. There is an intentionality to it that lands differently. But I had known before I opened the door that what was inside was manageable. The officer had given me enough information the night before to calibrate my expectations. I was not walking into something catastrophic. I was walking into something that required documentation, professional assessment, and a clear head. I walked through every room methodically. The damage was real, and it was deliberate. Fixtures that had been in good condition at the start of the tenancy were not in good condition now. Walls that had been clean were not clean now. Certain things that should have been where they were not where they were. The inventory I had taken on the day Lisa moved in, the photographs, the written record, the documented condition of every room, now had a counterpart. The before and the after, sitting in clear and undeniable contrast. I took photographs of everything, every room, every area of damage, wide shots for context and close shots for detail. I worked through the property the same way I had worked through everything else in this process, methodically, without rushing, making sure the record was complete before I moved on. It took about an hour. When I was done, I stood in the kitchen for a moment and looked at what had been a clean, well-maintained flat when I handed over the keys and was now something that required significant work before it could be occupied again. I felt the loss of it clearly. Not devastation, but a real and specific frustration at the waste of it. The time, the cost, the work that was now required because someone had made a deliberate choice to cause damage on their way out of a situation they had created entirely themselves. I called Peter from the kitchen. He answered quickly. I gave him a factual account of what I was looking at. He told me the steps, the insurance claim, the criminal damage documentation from the police, the formal record linking the damage to the tenancy and to the arrest the previous night. He said the photographic evidence I had just taken combined with the police report would give the insurance claim a solid foundation. He also said something I found worth holding on to. He said, "She has handed you the clearest possible evidence of why the eviction was necessary. Everything she has done since you first sent that late payment notice has strengthened your position and weakened hers. This is no different." He was right. The insurance company was called that same day. The claim was opened. The documentation was submitted, photographs, the original move-in inventory, the police report number, the record of the tenancy, and its history. The assessor came within the week. The claim was accepted without significant complication because the evidence behind it was thorough and the cause of the damage was clearly established. The repairs took several weeks. I managed them directly, getting quotes, choosing contractors, making decisions about what needed replacing entirely versus what could be restored. It was time-consuming in the way that any project requiring multiple trades and coordinated scheduling is time-consuming. But it moved steadily because I stayed on top of it. I visited the property regularly during the repair period, watched it return to itself room by room. The walls repainted, the fixtures replaced, the kitchen restored to the condition it had been in when I first listed the property. There is something quietly satisfying about watching a space be made right again. Not triumphant, just the plain satisfaction of a problem being systematically solved. The criminal damage charge against Lisa moved through its own process separately from everything I was managing. I was not required to do anything beyond provide the documentation I had already provided. The police had what they needed from the night of the arrest. The evidence was not complicated. I did not follow the proceedings closely. It was not my job to manage that outcome. It was the justice system's job. My job had been to follow the correct process at every stage, keep my record straight, and let the appropriate mechanisms do what they were designed to do. That was what I had done throughout. By the time the property was restored and ready to be listed again, I had been through almost 8 months of a process that had started with a late rent payment and ended with a criminal arrest and an insurance claim. 8 months of notices and hearings and documentation and professional calls, and the ongoing discipline of staying calm inside something that had every reason to make me lose my composure. I had not lost it once. Not with Lisa. Not in the hearings. Not the morning I walked through the damaged property. Not on the phone to Peter or the insurance company or anyone else involved in the long chain of this process. That composure had not been effortless, but it had been consistent, and it had made every difference. I sat down one evening with the full record of the tenancy in front of me. Every document, every notice, every communication. The paper trail that had started simply as good organizational habit and had become, over 8 months, the thing that won every stage of a process I had not anticipated being in. I thought about the version of me that had handed over those keys, feeling quietly confident. I didn't blame that version of me. He had done the right things. He had just been about to learn some things that research cannot teach. I knew them now, and the property was ready. I listed the property again on a Thursday morning. Same process as before in its structure. Photographs, honest description, fair price. But different in the things that sat underneath the structure, the layer of experience that now informed every decision I made about how to present the property and what I was looking for in response to it. The listing went up, and the application started coming in within a few days. I approached the review process differently this time. Not with suspicion exactly. I did not want to become the kind of landlord who treats every applicant as a potential problem. That is its own kind of error, and an unfair one to the majority of people who rent properties and treat them with perfectly ordinary respect. But I was more precise, more thorough, more attentive to the specific things that experience had taught me to look at carefully. References I now followed up on directly, not just reading them, calling the people who had written them, asking specific questions rather than accepting the written account at face value. The difference between a reference that has been given freely and one that has been given carefully, I had learned, is sometimes audible in a 2-minute phone call in a way it is never visible on paper. Employment I verified independently rather than relying solely on the provided documentation. Previous rental history I examined for gaps and asked about them directly rather than letting them pass unremarked. And I paid attention to the communications before the viewing, the questions people asked, the promptness of their replies, the general quality of their engagement with the process. Not as definitive indicators. Nothing at that stage is definitive, but as data points that contributed to a fuller picture. The applications came in over about 2 weeks. One stood out, a man named Andrew, mid-30s, stable employment in a professional role he had held for several years. 2 previous landlords whose references I called directly. Both gave accounts that were specific and genuine in the way that genuine references are, with the kind of detail that doesn't appear in managed ones. He asked sensible questions about the property before the viewing. He arrived slightly early. He was straightforward and unpretentious in person, not trying to impress me, just presenting himself accurately. He asked about the previous tenancy. I appreciated that question more than he knew. Not many applicants ask about the history of a property. It suggested he was thinking carefully about what he was committing to rather than just trying to secure somewhere to live. I gave him an honest answer. I said there had been difficulties with the previous tenant that had required legal proceedings and had resulted in some damage to the property that had since been fully repaired. I said the property had been restored to good condition and that the experience had made me more thorough in my screening process going forward. He nodded, said he understood, said he had rented before and knew that things could go wrong from both sides, and that what mattered was how people handled it when they did. That answer told me something. I offered him the tenancy the following week. The lease signing was straightforward. I walked him through every clause with the same thoroughness I had brought to the previous tenancy, but with a clearer sense now of which clauses mattered most and why. The payment terms, the notice requirements, the condition of the property, and the documented record of that condition that we both signed to acknowledge. He read the agreement properly before signing it. Not skimming, actually reading. I noticed that and noted it. He moved in on Saturday. The first month's rent arrived the day before it was due. I checked my account on the due date out of habit and found it had already been there for 24 hours. I sat with that for a moment. The simple, quiet relief of a process that had cost 8 months of difficulty producing an outcome that felt, in its ordinariness, like exactly what I had been working toward. The months that followed were unremarkable in the best possible way. Rent arriving consistently. No complaints from neighboring properties. Occasional brief contact from Andrew about minor maintenance matters. Reported promptly, described clearly, easy to address. The behavior of someone who understood that a rental property was someone else's asset and treated it accordingly. I found myself thinking sometimes about the contrast. Not obsessively, not with any ongoing bitterness about Lisa or what she had put me through. Just the occasional quiet observation of how different the same property felt when the person living in it had a fundamentally different relationship to their obligations. Andrew stayed for 2 years before his circumstances changed and he needed to move. He gave proper notice well in advance. He left the property in excellent condition, better in some small ways than he had found it, because he had taken care of minor things without being asked. He asked if I would provide a reference for his next rental. I wrote it without hesitation. And unlike the carefully managed reference Lisa had provided at the start of all this, I wrote it freely, with specific detail, because everything I said in it was true. Peter sent me a brief update some months after the criminal damage case had concluded. Lisa had faced the charge. The outcome was what the evidence had always made likely: a finding against her, consequences attached. I read the update once. Then I filed it with everything else from that period and moved on. I want to say something about that filing, about the decision to put something away rather than carry it. I had spent 8 months being professional, methodical, and composed inside a situation that had every reason to make me angry. The late payments, the fabricated complaint, the deliberate damage. Each of those things had been a choice Lisa made. A choice to escalate rather than resolve, to fight rather than accept, to damage rather than simply leave. None of those choices had produced a single good outcome for her. Every escalation had strengthened my position. Every fabrication had collapsed against the documentation. Every hostile message had been noted and filed, and had contributed to the record that ultimately won every stage of the process. And the final act, the damage, the arrest, the criminal charge, had been the most self-defeating choice of all. The eviction was already granted. The complaint was already dismissed. She had already lost everything there was to lose through the legal process. And she had added a criminal record to it. I did not feel satisfaction about that. I want to be honest about that. There is no version of this story where someone else's bad outcome produces something that feels good. What I felt was something closer to the recognition of a simple truth that this entire experience had illustrated with unusual clarity. The process works when you follow it correctly. Not quickly, not without cost and time and money and the ongoing stress of something unresolved. But it works. The documentation matters. The professional advice matters. The composure matters, not just practically, in the way that a clean record matters to a legal outcome, but personally. The decision to stay measured and professional at every stage is the decision that keeps you on the right side of every line. Lisa had crossed every line available to her. I had stayed on the right side of all of them, and the outcomes for each of us reflected that exactly. I still own the property. The tenant after Andrew has been straightforward and reliable. The screening process I now use is thorough, without being invasive. The lessons of that first tenancy applied practically and proportionately to every application since. I think about that first tenancy occasionally, not with residual anger. That has been gone for a long time. More as a reference point, a clear and thorough education in what can go wrong and how to respond to it when it does. I did not know any of what I know now when I handed Lisa those keys. I know it now. And every decision I make about this property going forward is made by someone who learned it the hard way and came out the other side with their composure intact and their documentation in order. That is enough. That has always been enough. If this story gave you something useful, whether you're a landlord, a tenant, or just someone who has had to navigate a difficult process and wondered whether doing things correctly actually makes a difference, leave a comment below. I read every one, and if you want to hear another story, the next one is already waiting. I'll see you there.